Welcome back. Will Worsham joins us now for this week's Speaking Legal Discussion. How's it going, Will?
Hey, did you ever play baseball?
Did you?
I played baseball for a little bit.
Did you really?
You got a good arm.
That does not surprise me.
Not a pitcher, but
Oh, you weren't? What position did you play?
I played catcher a lot of the time.
Really?
Oh.
Yeah.
I played pitcher.
Did you?
Yeah.
Good.
I've never played.
Okay.
So we get that out of the
Oh,
way.
yeah. Anyway,
Well, it's always
I was
good-
just curious about that.
Yeah.
Okay. Well,
Anyhow.
now that's
well,
out of the way.
we do want to get to today's legal question.
Sure.
Just, you know.
Yeah, we'd love to. Let's get right to
Let's
that.
get right to that. Okay, here's your question, Will. If we want to appoint a guardian for our children, can we do that with a will, or is there something else we should do?
You can do that in a will. It's probably not the best way to go about it because, once again, a will goes into probate. And so if you establish a guardianship through a will, it's going to be administered by the probate court. Probate judge is going to have to oversee everything that guardian does. So you're creating a scenario where you've got some difficulty like that. A better way to go about it is to go ahead, like we recommend in a lot of situations, go ahead and create a living trust. Because you can then appoint guardians over your minor children in that living trust, but then the trustee, the successor trustee, if you were to pass on or whatever, they then can administer that trust by the terms of the trust without any judicial oversight.
So is the trustee,
Right.
is that the same person as the guardian, or are they two different people?
They could be two different
Could be
people.
two different people.
You could
Oh.
have the trustee that handles the money situation, and so they
Right.
could, and then the guardian could be the one that makes the decisions for the child about, health care and schools and all that type of
gotcha.
stuff.
I know we've talked about this before, but it just seems like a trust covers so much more and keeps that out of probate. What's the reason for a will?
Well, the will really is kind of an antiquated method of how we used to handle transmission of property upon someone's death. It was the way it used to work, and I suppose in times of all this that we do comes from Old England, when there's kings and vassals and
Things
feudal
haven't
law.
changed, haven't they?
Well, there's a lot that passes down, and the law in and of itself is very, it venerates old law. And so
Yeah.
you look for precedent and what's been done before. And so to change that, sometimes it's a little bit slow as the law is developing. So trusts are a relatively new invention because the law is so old. I mean, we're talking
Right.
all the way back to England.
Right.
Whereas-
How old is the trust? How long have we been doing it?
Yeah, we've been doing it for a long time, and more than my lifetime by for sure.
Right.
Yeah.
But it doesn't go back to the way the old wills were, where you would, as a lord and a landed gentry, you would write out your will and how everything was going to go like that. And then the king would enforce that.
Right. Right.
Could I throw a wrench in the question?
You
just
can
because
try.
I just
I'm sure
thought
you'll be
something.
successful.
You know how people contest wills all the time. Let's say you have the guardian picked, and there's another family member who wants the children.
Right.
Can you contest that?
Well, like I've said before, anybody can sue anybody for anything at any time.
Right.
So you can always go to court and file a challenge to anything that you want. Now, whether or not that'll be successful could depend on all kinds of factors. But when you create a trust, you have to be in your right mind to do so. You can, just like if you're making a will, you can't be under undue influence. And so if someone could show that any of the criteria that has to be met for someone to create a trust was not present, then it could be challenged. It could be theoretically set aside.
And does it automatically go, let's say a mother has children from a different father and she gets remarried, does it automatically go to the birth father in that situation, or would it go to the stepfather? How does that even work?
Are you talking about guardianship?
Yes, guardianship.
Okay, that's you can't modify parental rights in a trust document. So if the father is alive and able, then they're going to have the same right. Their rights would not be modified just because the mother passed away.
I gotcha.
Right.
Okay.
Does that make sense?
Yes. All right.
Very interesting.
I know. There's so many technicalities, and I know people can
Yeah.
contest wills all the time. It's
Right.
almost like your last wishes can be totally strung through the courts for years,
yeah.
and that's what you wanted to be done.
And well, that's what we want to avoid, because that's why we want to do a trust. And
Right.
that way we get everything out there the way you want it. When anything happens, it's going to be taken care of the way you want it to be taken care of.
Right.
Right.
And
All
so
right.
make sure you do that, and maybe have a witness there to prove your sound mind
Well,
body.
yeah, if you want to, you have to have your signing ceremony, and we have witnesses present, notaries. There's a
Notaries,
certain-
yeah.
Do you have to have a
certain
doctor's
things.
note? Here's my doctor's note.
Maybe it depends on some circumstances. Yeah, if there's any question about competency,
Yeah.
you probably would want to have a doctor's note.
Absolutely.
Absolutely
All right,
awesome.
Will. Thank you so
All right.
much.
You're welcome.
If you have a legal question for Will, you can email him at wworsham@color10.com, and he'll answer your question right here on the show. Thanks, Will.
That's right.
You're
Thank you,
welcome.
Will.